Constructive fraud, see also fraud. This cause of action arises in equity where one person either occupies a fiduciary relationship to the other or the other suffers mental weakness or similar infirmity that prevents his or her form of understanding. For example, if an elderly person or weakened mental ability signs a deed transferring his or her home to another for substantially less than the home is worth, a presumption of constructive fraud arises. The action arises in equity to prevent the unjust consequences of the defendant's wrong. Constructive fraud may exist even where the defendant had not intended to defraud. The gist of the cause arises from the duty of each of us to do justice to others and not by halves, right? The old adage of caveat emptor, let the buyer beware, has been displayed by societies needed to protect innocent people from unjustly enriching wrongdoers, either through ignorance or inability to understand whether or not the wrongdoer is aware of his wrong. Now, I want to point something out here. I love the words that this guy is using in this. Wrongdoer. That's common law. That's the exclusive jurisdiction of equity. That's tort language, okay? We're not talking about persons. We're not talking about illegal. We're talking about unlawful. We're talking about wrongdoers. We're talking about equity, okay? So these words are articulating the jurisdiction for which this venue, this court shall be held in, all right? We're talking about jurisdiction here. So, from unjustly enriching wrongdoers, unjust enriching is, again, it's an unlawful act. It also happens to be illegal as well, but when we're talking about it on the legal side, it would constitute something like extortion, okay? That's a legal word for unjust enrichment, extortion. Enriching wrongdoers, either through ignorance or inability to understand whether or not the wrongdoer is aware of his wrong. The duty each of us owes to all others arises from moral, social, domestic, and even personal obligations imposed by equity in our courts. All right. Again, it's equity. On the commercial side, they envy equity, okay? And to prove my point, they have duplicated everything that is on the common law side of things, from your writs of quo warranto, your extraordinary writs of habeas corpus, your memorandums, all of that stuff pre-existed the commercial side of things that has auxiliary, current, and exclusive as well, all right? And so they're just a mirror image of each other, basically. Only the lawyers use the legal side to muddy the waters and to manipulate things. Remember, a twisting of the language is unworthy of a judge. He who contradicts himself shall not be heard. There's a number of maxims I can lean on and weigh on that describe the legal society. Legal and lawful are two different things. They're apples and fucking oranges, okay? One is under Roman civil law, military occupation, and the other is on the private side, okay? Where men's rights are. On this side, you have civil privileges, civil rights, privileges, and immunities. And on this side, you have unalienable rights, substantive rights, what's right, just, and fair, what's moral, right? And so that, I hope that helps put things into perspective of the difference between legal and lawful, all right? And what he's describing to me, every word in here that he's describing thus far is screaming to me. This is Article 3, Subsection 2, Subpart 1, qualified venue before a chancellor who uses the administration of the grace of the eloquent grace of the Heavenly Father. All right, they are charged with the duty of administering grace on behalf of the Heavenly Father. Okay, so the duty each of us owes to all others arises from moral, social, domestic, and even personal obligations imposed by equity in our courts. If it's from this duty and to protect innocent people from the wrongs of those who breach this duty, that the cause of action for constructive fraud arises, also may be called unjust enrichment, honest services fraud, okay? Elements. 1. Plaintiff, through no fault of his own, reposed trust in the defendant. 2. Defendant abused the trust, obtaining unjust enrichment from plaintiff's injury, okay? If they're getting paid by the Treasury to unlawfully accost you against your will, in an unlawful and illegal search and seizure or act, absent a warrant, absent a crime, absent an indictment, which is a true bill due and owing, then they're in breach of their fiduciary duty. They're engaged in fraud, and they're making you subject to their edicts on a whim under the color of law that they're justified in what they're doing. And I will tell you right now, you can hold these people abso-fucking-lutely accountable. And because so many of us are becoming learned, we got word recently from Cincinnati, Ohio, from a chief of police over there, or a deputy chief of police, that they are going through extensive training now to make sure that their outfit is well within the confines of the Constitution and that they don't overstep their boundaries, because the amount of liability they are now carrying is so surmountable, it's unreal, okay? So they're really trying to restructure the system by informing their agents and agency, hey, look, people are becoming learned to our little tricks, schemes, and simulated legal processes. And because of that, you have to conduct yourself in a certain way or you're going to carry the liability, because we are restructuring the way that we're doing things. And if you fall outside of our instructions, we're going to leave you out to dry on your own. It is not necessary for the defendant to occupy a relationship of trust with the plaintiff. However, such a relationship does strengthen plaintiff's case, for in each case, the cause of action arises from the defendant's abuse of plaintiff's trust, imputed, implied, or actual. It may be based on misrepresentation or concealment. However, in every case, the defendant gains an improper advantage that equity arbors as a wrong. Remember, equity will not suffer a wrong without a remedy. The facts that can result in an action for constructive fraud are widely varied, but in each case, the defendant has taken unjust advantage of the plaintiff. Conversion. The civil action of conversion is similar to criminal theft. However, it involves the taking of tangible personal property only. The taking of money or real property does not give rise to this cause of action. The gist of it is exercising dominion or control over the tangible property of another, like a fountain pen, automobile, or computer system. That is inconsistent with the owner's right of possession, i.e., conversion deprives the rightful owner of his property without consent. Oh, unlawful conversion. Let's talk about foreclosures, baby. How about that note where they converted it from a promissory note to pay into an order to pay and then tried to drag you into the court under false, fraudulent pretenses that you owe a debt when they've rightfully been paid, all right? That's why you're making repayments. Well, when you're repaying for something, that presupposes that you paid for it in the first instance, doesn't it? Why would you be repaying, okay? Why would you be making a repayment? Just think about it. It's just cognitive thought process here. The wrong is not in the taking, but in the depriving. The depriving need not be permanent. Any wrongful deprivation of the right of an owner of property to enjoy possession of his property is, if the property is not money or real property, ergo land and building attached to the land, conversion. Elements. 1. Deprivation of plaintiff's rights to enjoy possession of tangible personal property, either temporarily or permanently. 2. Plaintiff demands for return and defendant's refusal to return, not necessary where plaintiff can show the demand would be futile or impossible. 3. Damages to plaintiff. Demand and refusal is an essential element in some jurisdictions. To overcome the necessity of this element in jurisdiction that permit it, plaintiff must show the evidence that demonstrates the futility or impossibility of demand. Mere alleging it will not suffice. The element of intent may not be necessary in some jurisdictions. The damages awarded for conversion is the fair market value of a thing converted at the time of the conversion plus legal interest to the time of the verdict. See Replevin. Defense. Consent. There is no conversion where the plaintiff gave defendant permission to possess plaintiff's property, i.e., when you did a blank banker's endorsement without restricting your endorsement on the note, all right? And they converted it, so it's not an unlawful conversion because it was a blank banker's endorsement. You allowed them to be able to do that. This is true even where plaintiff gave only temporary permission and defendant continued to hold the property past the date when it was to be returned. Failure to demand. Plaintiff's failure to demand, see notes above, may be a defense if defendant can show he lacked intent to convert and would have returned the property promptly if the plaintiff demanded its return. The defense arises where defendant had the mistaken belief that he had the right to possess. Very gray area. Check local case laws. Now, let me tell you something about a little bit about foreclosures, baby. You don't get to eat your cake and have your ice cream too in my world. If you want the fucking house back, fine. But I demand and I compel you to bring back the original note with wet ink signature and all rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, rents, profits, proceeds, futures, and annuities. Okay? I want it all. Because you ain't getting them both. You can have the house. Fine. Fuck it. Don't care. But I want everything else. And if you can't bring it all back to me, then guess what? House is mine. The mortgage is cut in half. Because when the mortgage and the note were separated, it voided everything in ab motherfucking initio. All right? Money. Money being a fungible item like grains of wheat in a Kansas silo, a count for conversion will not stand unless a particular instrument of money can be identified. A coin collection, for example, can be converted even though it is technically money. In most cases, a cause of action for conversion of money will not stand against this defense. Ownership. If the defendant can show the plaintiff did not have an ownership interest in the property at the time of the conversion, this defense arises. Only plaintiffs with ownership interest in the property can assert the clause. Arguably, one who purchased property for another after it had been converted does not have this cause, but must pursue his remedy against the one from whom the property was purchased. That brings me to another very valid point about mortgages. Ladies and gentlemen, go down to your local register of deeds. Go pull out your warranty deed, joint tenancy deed, trust deed, grant deed, quick claim deed, quiet title deed. I don't give a shit what it is. And you will find that your name isn't on that document. It is an unidentified, unregistered, unknown, false and fictitious name. Do yourself a favor, take the warranty deed, grant deed, joint tenancy deed, whatever the fuck it purports to be, and go down and file for your assumed business name where you are the owner of it, okay? And attach that motherfucker to the warranty deed, grant deed, special tenancy deed, whatever the hell it is, okay? Attach it to it. Now, the owner is known. Now, you have grounds to prove that you own it, or you have an entity that owns it, and you have a collected interest in it, all right? During a foreclosure, what the lawyer is really doing is saying, Your Honor, we're coming in here as trustees on behalf of the unknown, unverified, unidentifiable beneficiary, the one who really is the owner. This man over here purports to be the owner, but really he's only entitled to subrogation because he really doesn't know if he is the owner. And we have no physical evidence before this court that he is the owner because, of course, the note with the mortgage package and the warranty deed weren't all filed at the Register of Deeds, so we can't prove that he paid anything, first of all. Secondly, we can't prove that he owns the property because, again, this is a false and fictitious, unknown, unverified false and fictitious assumed business name that nobody has registered. So when we're foreclosing, I'm actually the attorney, and I'm just here on behalf of the beneficiary, who again is unknown, unidentified. We can't find them, and in the interest of that unknown, unidentified, unverifiable real party in interest known as the beneficiary, which is also equates to the real owner of the property, I'm stepping in on behalf of that individual to ensure that their rights, titles, and interests to said property are protected. That's what they're doing. That's the reality of it. All right. So protect yourself. Go in there, get the assumed business name. There's some other tricks I can show you, and they're really not tricks. It's just the law. It's just the law. There's nothing schemy or Weasley about it. It's just what needs to be done. Remember, equity will not perfect an imperfect gift. And you have to acknowledge and accept the grant deed or the warranty deed or the joint tenancy deed from the grantor. You have to accept and acknowledge it and file it on the fucking record that you're accepting and acknowledging it as the beneficiary or as the grantee. Okay, become the grantee absolute, where the beneficiary and the trustee are the same person, and now you've collapsed the trust, and the real interest in the property has to be disseminated to the beneficiary. All right, and then move it over into a trust. Real simple shit. Anyway, when we come back, we're going to be touching on declaratory judgments. I'm going to go ahead and stop this audio now so we can get back into declaratory judgments. Declaratory judgments are a lot of fun. This is something that a lawyer will tell you, oh, that's old shit. We don't use that anymore. Of course you would say that as a lawyer, because you as a lawyer cannot get a declaratory judgment, because part of the prerequisites of a declaratory judgment is that somebody has to fill out an affidavit, and a lawyer isn't qualified. Trensleigh versus Pagliaro. Although statements made and arguments in brief are flattering to the court, they don't grant rise for a summary judgment. Why? Because the lawyer can't substantiate his claim with firsthand knowledge, perfected knowledge, on an affidavit. Therefore, the same thing applies with a declaratory judgment. Declaratory judgments are what men receive, men and women, okay, because they can affirm with firsthand perfected knowledge on an affidavit, swearing to it under the pains and penalties of perjury. I think it's Title 28, 1746. Look at number 1, unsworn declarations. I would use number 1, okay, because it's under the laws of the United States of America, not under the United States. So keep that in mind. If you're going to use a notary, there's a jurat, and the jurat gives the simple statement of fact that you're doing this under the pains and penalties of perjury, understanding all the laws, blah, 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 blah. So just food for thought when you're doing and executing processes. Knowing some of these little tricks will help you along the way. Now, we will come back to declaratory judgments in the next video.